Mr. Huey, you can start whenever you're ready.
All right, give me 1 second to unload this stuff.
No, take your time, but start whenever you're ready.
Your Honor, my name is Mike Huey, and I represent the Florida Association of American Institute of Architects. We're here as appellates, appealing the order
Okay,
entered.
Mr. Huey, you have the same problem that I do. Unless I try to talk loud, I can't.
Okay,
So,
better,
yeah,
better, sorry.
thank you.
Did you get my name? My name is Mike Huey. I represent the Florida Association of the American Institute of Architects, and we're here appealing an order by Judge MacArthur, appealing a proposed rule promulgated by the Florida Building Code Commission. I would like to reserve 5 minutes for rebuttal if possible. First of all, I would note that it is a little ironic, I guess, that we're here a week or so after these tragic storms, and we're arguing over whether the code, which is 9 of those volumes over there, should remain static and only be tweaked through an amendatory process dealing specifically with things related to Florida, or whether the code should be updated every 3 years, as we contend the statute requires. The commission proposed a rule which...
Well, take me through under your scenario, your argument.
Okay, sir.
What happens in the adoption process every 3 years?
The law got changed in 2017.
I know it changed, but
Right.
under the new scenario, take me through that. How would that occur?
Under the new scenario, I think you follow the statute. The commission is directed to use these international codes.
We're
Okay.
directed to review them under the statute. It doesn't say they use them, does it?
It says to use them, in 55373 says the commission shall use the international codes for updates to the Florida Building Code. And then in 7A, it says the commission shall adopt an updated Florida Building Code every 3 years through review of these codes.
Okay, but if those codes are the starting point, which it seems what you're saying, how is it different from the former statute? Because it wasn't that what the former statute did, said?
No, the former statute mandated that the commission adopt these codes.
It mandated it.
Yes,
So my
it said
question to
you
what
shall
I'm having
adopt
tr- Let
these
me tell you what I'm
codes.
having a problem with. If they're no longer required to mandatorily adopt those codes, how do they know which sections of the code to use? You understand my question? Because
Oh, I understand your question. Yes, sir.
and that's part of my problem with your argument at this point that I'm not understanding.
Well,
What is their standard?
Well, the
what parts
standard-
of the codes to use?
the standard is you use the other parts of the chapter and to frame what your authority is and what you're supposed to be regulating and what you're supposed to be protecting. And you look at these codes and you determine whether those codes are needed as updates in the commission's discretion as part of what an agency does.
So they get to pick and choose,
Yes.
but on what standard? Just that we think it's
Well,
good?
first of all, the standard is the legislature has identified the codes that you work off of. Okay? Secondly, the legislature has outlined in other parts of the building code, and I can go through it, but it's outlined what their powers are, what their authority is, and it's outlined the things they're supposed to be dealing with.
But aren't we
Residential
dealing,
code.
aren't we dealing with your interpretation, aren't we dealing with a question of a legal delegation? Just saying you pick and choose which parts of the code you want?
Well, that very frankly was what Judge MacArthur found, and we would disagree with that.
Okay.
We would say there's plenty of standards in the building code, in the power that's given to the commission for them to have the wherewithal to go through the codes that they're mandated to review and choose the applicable updates which they're mandated to adopt into a new Florida building code.
And I guess I'm a practical application type person, so I guess if we boiled this down, we went from a model code foundation system in 2017, now it's a Florida building code focus, and then you can review the model codes with an emphasis on specific to Florida. So your clients, from a practical application standpoint, what's the problem with this switchover? How does it create confusion? Do you think there's going to be holes with respect to, say, hurricane codes?
Here's our problem. They have morphed everything in, and Judge MacArthur found this. She said they've inverted the whole thing. So now you take these 9 volumes, and they don't change except for technical amendments, which have been clarifications, tweaks, as she refers to it in her order. Okay? So in the past, you looked at all the updates, forget how many are out there now, about 1,000 or so for the last session. You look at all the updates and you adopted those. The legislature said, no, we're not going to mandate the commission to adopt every one of those anymore, but we are going to mandate that they review them and that they adopt by rule an updated Florida building code. Now,
If I understand your argument, and correct me if I'm wrong, you're basically saying that if you take the department's position at this point, you can't adopt any of the new code unless it shows that it's specifically needed in Florida.
that's exactly right.
So basically, the practical effect is you're saying we no longer get the benefit of the new technology that is adopted in the codes.
That is correct. I'm
Okay,
saying they have
I
morphed
understand that argument. I think it's a very good argument, but isn't it a policy argument more than it is a legal argument? Hey,
No, sir.
legislature, you screwed up.
No, sir, I don't
Excuse the
think so.
language.
I don't think so. I think the screw-up was interpreting that 7A no longer has any power, that it is morphed into nothing but an amendment process, because why else would the legislature go to 55373 and change it when it says you shall use the international codes to develop or to incorporate updates into the Florida Building Code, and then go to 7A, 553-7A, and say, you must review these codes. Why would they go to the trouble of that if they were only saying the only way you're going to change these codes going forward is by tweaking through amendment? Why would they go to the trouble of saying it the way they did if the legislative intent was that adoption of the Florida Building Code really is only through a technical amendment process? That defies the use of the term adoption from the beginning of the code all the way to the end of the code as being a separate process than an amendment to the code. Now, they seize upon 7C, which is where Judge MacArthur went to, and said, well, right down here in 7C, it says the commission may adopt any portion of the codes identified in paragraph A, but only as needed to accommodate the specific needs of the state. They didn't say the commission may only adopt provisions from the codes above, and only if they do this. In other words, C is a permissive provision. So if they see something in the codes that they did not incorporate into the Florida Building Code when they adopted it under the triennial process, At any time, they can go back later, but at that point, it's going to be treated like every other technical amendment. And those technical amendments are set out how they're treated in the statutes. That's what they refer to this as, a technical amendment. 7A doesn't deal with technical amendments. What the argument was, and we didn't win the argument before Judge MacArthur, what the argument was, 7C trumps everything. All the stuff in 7A doesn't matter anymore. There's no more updating process. Well, if that's the case, the legislature didn't say that.
Down to 5 minutes.
Okay, I'd like to reserve my time. Thank you.
May it please the court, my name is Justin Vogel and I represent the Florida Building Commission.
Okay, I'm going to ask you to talk on the microphone as well.
Sorry, yes, Your Honor. My name is Justin Vogel and I represent the Florida Building Commission, the appellee in this matter. I'll address some of the issues that Mr. Huey has brought up. Some of them, as this court has noted, are really policy issues, but there are some, I would say, mistakes of
Could the
law.
legislature have intended that you only adopt the new codes if they show, those portions that show a special need in the state of Florida? I mean, it doesn't make sense to me. Mr. Huey's argument boils down to that. I mean, this whole thing, can they
Boils down
adopt
to
anything?
the commission can adopt any updated provisions from the model codes so long as the commission makes a finding that the state of Florida has a need for that provision. Now,
State of Florida versus Georgia or North Carolina or South Carolina?
this argument that seems to have come out in some of the later briefs from AIA seems to imply that that in order for it need to be Florida specific, that it has to be unique to the state of Florida. Well, that is not any kind of position that the commission has ever taken. And this language pre-existed the 2017 changes to the statute. This language was present in 7C before, is also present in subsection 9. Never has Florida-specific need ever been interpreted to mean unique to the state of Florida.
Well, I mean, in the past, though, prior to 2017, wasn't it used as sort of a technical amendment type standard? Now it's nothing goes in unless it meets that standard.
Yes, prior to the legislative changes, when the foundation codes were the model codes, the I codes, when they were being brought in order to change it, during the triennial update process, there had to be a finding that there was a Florida-specific need to do so. They were brought
What
in
does
by
Florida-specific need mean?
that is defined by the rule. It's a need that the state of Florida, that the commission specifically identifies that this state needs. And so that doesn't necessarily mean unique. I mean, I think that you'd be hard-pressed to find any kind of construction-related issue that is entirely unique to the state of Florida. That would be a very difficult standard to meet. But as I've said, this language existed prior to this amendment to the statute, and it's never been
And I want to hear
interpreted
your
that way.
explanation on this. Before it was for amendments to be made. Now it seems to be a broad, precursor to any change. So how can you argue that isn't it now used quite differently, post-2017 amendment?
I wouldn't say that the definition is used, I suppose, differently. I think that there has been a definition that's provided in the new rule. As far as the process, yes, there has been a substantial change to the process in how the code is updated triennially, because prior to the change, all of the model code provisions were brought in by default. And now there's been essentially a shift in burden, because prior to the change, you had to show that there was a Florida-specific need required to deviate from the model code provisions when they acted as the foundation. Now that the Florida Building Code is sitting in the place as the foundation, the burden is that in order to bring in those model code changes, they change every 3 years, in order to bring those in, you have to show that there's a need that the state has.
Let's say,
To make-
I know nothing about building, except I'm, building a house right now, and it shows I know nothing about building. Let's say the code gets updated for a higher level of insulation is required. The new code. What is specific to Florida? Maybe that's a bad example because of the heat, but trying to think of something that just may be a technology change. Maybe there's now a super staple that can be used versus nails nailed down a roof. How can you show that was a specific need to the state of Florida?
Well, essentially, the commission would have to just make, someone on the commission itself would have to make that determination. The rule provides definitions, or within the definition, provides criteria that can be used to define what is needed to accommodate specific needs of the state. In your example, Your Honor, there's a design under, I believe it's subparagraph F, or for industry designs and standards. Frankly, that would be something that would potentially fall under that. It's also not an exhaustive list within the rule.
Yeah, under the old system, the code was automatically adopted. Under the new system, is every adoption of anything that's adopted, would it be subject to challenge? As not meeting a specific need in Florida?
It would be subject to challenge. I mean,
Any portion of the code that the commission decides to adopt?
people can make that argument. I mean, subject to challenge sort of at what stage? Frankly, there's a lot of opportunities for stakeholder involvement throughout the code development process. This, as far as sort of capturing these technological improvements that you're alluding to, it's true that under the new way of updating the code, because the commission has to go through every model code change one by one, there's a greater level of responsibility on the commission because it has to go through and look at them and determine whether the state would have a need for it. In your example, for greater insulation that has more value, maybe that would very well be adopted. There's also a greater level of accountability for the building commission when it brings in something or when it makes a determination that something is needed to accommodate a need of the state. And so as far as challenging what can be brought in, I don't know how someone would do that sort of beyond the usual stakeholder
Is it required to be
participation
adopted by
processes.
rule? Or
I'm sorry?
is the building code required
It
to be
is.
adopted by rule?
It is, and
So
so
that somebody could file a rule challenge at any point,
I guess if they're alleged that there was some deficiency in the process. And so the commission has to make that determination based on the input of its technical advisory committees, based on public input, and ultimately upon the decision of
Okay,
the commission as its
and I might be reading the wrong language because this is a note I took. It says accommodate special needs of the state. What does the word special mean?
Where is
I mean-
special needs of the state, Connor?
Amendments to Florida code containing new model codes must accommodate special needs of the state. Am I quoting the wrong language?
Yeah, it's specific.
I think it would be specific needs of the
Specific
state.
rather than special, okay. What does the word specific there mean?
I would say that this state has a need that's been identified by the Florida Building Commission for whatever that provision is.
Now, can you describe for us what specific verbiage of the amended 55373 supports the commission's position in the proposed rule that the adoption is always based on specific needs to the state? Where is that supported in 55373, the 2017 amendment?
Found in paragraph C of subsection 7. That's really what most of this litigation is boiled down to, sort of a debate about what that particular paragraph, how that operates now after the legislative changes. I mean, essentially what the appellant is arguing is that the legislature created another means of introducing interim amendments to the code, like with subsections 8 and 9, but rather than creating a new subsection, took a paragraph from subsection 7, one which everyone, including the appellant, agrees applied to the triennial update before and severed that connection. But they left it in the same place with internal references to the same subsection and to other paragraphs within the subsection which address the triennial update.
Well, I think appellant argues that there is a qualification when it says technical amendment, and it's my understanding technical amendments can be made during or in between the triennial review process. So aren't we looking at two different, when we say adoption versus amendment, a technical amendment can occur in between that 3-year adoption process? So is there specific language you can point to that says for the triennial review adoption process, every adoption must be based on specific needs of Florida, other than the technical amendment verbiage?
The Commission's position is that subsection 7 generally addresses the triennial update. And so within 7C, it does not specifically say triennial update process. It does talk about other parts of the updated code. And I believe that it is referring to the work in progress when the Commission is updating the code. And so that language is found in 7C updated code also throughout subsection 7, which I think has always been related to the triennial update process. Now, the means of introducing technical amendments in the interim period, that's found in subsection 9, and that's an entirely different type of technical amendment. I mean, approving technical amendments has always been part of the triennial update process. Really, nothing has changed in that respect. What has changed is what is being amended. Before, it was the model code provisions, which acted as the foundation for the building code and which came in by default. But now, it is the existing Florida building code which sits in the place as the foundation. And these amendments are separate from the interim amendment procedures that are found in 8 and 9. And really, I don't think this even seemed like a controversial point at the outset. On page 13 of the record, in the original rule challenge, the appellant had this to say about the rule, that consistent with the amended statute, the proposed rule states that the Commission may amend the Florida Building Code to update the Florida Building Code every 3 years pursuant to subsection 553.737. I mean, I think that they have presented some inconsistent views on appeal, but their arguments are contradicted by the plain language in the statute and just the statute's organizational structure. With respect to their policy concerns, with respect to the possible effects of the changes to the update process, I did just want to say that and reiterate that the fundamental reason for the change to this process is not the rule that is being challenged here today. It's the statute that was passed by the legislature. The Commission did not set this policy. We are simply following out in accordance with our duties. And so, Your Honors, I guess just to recap, the Commission only promulgated the changes to the rule in order to bring it into conformance with the statute. The intent and effect of the statutory changes the Commission feels are clear, and the rule properly reflects the changes to the triennial update process that the legislature enacted. And so, accordingly, unless there are any further questions.
Let me ask you a question.
Yes.
If we adopted an opinion saying we uphold, and I'm not saying we're doing this, we adopt an opinion that said we uphold the ruling of the JCC, but clarify, taking the position taken by the department here today, that specific needs of Florida does not mean to the exclusion of needs of any other state. Is that give the department heartburn?
It doesn't sound like it from what you're generally describing, because, I mean, as
No,
I
I'm
said,
just saying that their whole argument seems to be, hey, in order to adopt this, you need to show this as a special need for Florida only. I mean, that seems to be their argument. You said today that that language doesn't mean that.
no, that's correct. I
Yeah,
mean,
so all I'm
and-
saying is if we adopted opinion basically saying that we affirm the hearing officer based on the department's representations, that language doesn't mean that something has to be specifically needed in Florida, just that it is a need in Florida.
Well, I mean, as far as specifically needed in Florida, it does have to be needed in Florida. It does not have to be unique to the state of Florida.
That's what I'm saying. I
Okay.
mean, I'm not phrasing it well. But would that cause the department heartburn?
I think I can speak for the commission when I say that no, it wouldn't cause the commission heartburn because, like I said, this language has been present in subsection 9, in subsection 7, I believe since the beginning. And I don't recall that it has ever been interpreted to mean unique to the state of Florida. And as I've also noted, I don't recall this argument being brought up earlier. I mean, if that was kind of the only concern, then it might be
I'm
odd,
trying to
but-
establish it, and maybe you guys could meet outside and resolve this before we do anything.
Well, I won't speak to that, but we would ask that the commission would ask that this court affirm the ruling of the lower tribunal. And thank you for your time and for your attention.
Mr. Huey,
Yes, sir, Your Honor.
you heard what I proposed to the other side.
I did hear what you
You know, I
proposed.
guess it's a win and a loss for you, but would that language cause you heartburn if we did that?
Yes, sir.
Why?
Because I think it still puts a legal test. You mentioned, could somebody still challenge these amendments? I think they could. There are a variety of interested parties when it comes to building, design, and construction that have their own ideas about what they would like the code to do or not do. And from the designer's standpoint, we're dealing with it on the front end, trying to abide by the Bible and the laws on all these structures. So I still believe that would not solve the problem. I would like to go to a question that Judge Thomas was asking, and that was about what they were trying to do here and putting this test on. And let me give you what the administrative law judge said at paragraph 33. She said the 2016 law plainly reflected a policy choice to primarily use the model codes for the Florida Building Code with only necessary tweaks made to meet specific needs of this state. Just as plainly, the 2017 law reflects a policy change. While the existing Florida Building Code may largely reflect the model code provisions in effect at the last triennial update, on a going forward basis, the 2017 law inverts the presumption that the model code updates should be used absent a showing of changes needed to the model codes to accommodate Florida-specific needs. Now, that's her order. That's actually what was argued before her. We think that's not an appropriate, and we don't think that's an accurate interpretation of what the legislature has done. If you go through the building code, and you can go from the front to the back, 55373, the commission shall adopt by rule the Florida Building Code. The Florida Building Code shall contain, excuse me, the commission shall use the international codes published by the International Code Council for updates that shall be adopted by a rule.
Well, what did the legislature do then? Because if it's still...
Here's what the legislature
Well, I
did.
mean, what was the 2000 amendment all about?
Here's what the legislature did. They said, no longer are we going to mandate that you have to adopt the set of documents that are sent down by the International Code. However, we are still telling you those are the Bible. We want you to review those and use those when you do your triennial update. And a triennial update, if you look at the code, a triennial update is consistently referred to something different than amendment of the code. Adoption of the Florida Building Code.
Practically, though, I'm trying to figure out, you're not really answering my question. What did the 2017 amendments do if they are still required to use those codes as their starting point?
Well, before they were required they weren't given any discretion. Before, they were mandated to adopt those by rule, period. Now they're told, you still have to use those, but we're not going to mandate anymore that you do it. The administrative law judge says, well, that takes all their authority away. Well, that's not true. It doesn't take their authority away. What they've done is review these codes and use your authority, use your power, which is vested in them in the building code, in terms of coming up with a new updated Florida Building Code, which is consistently mentioned that they've got to do every 3 years. That's not subsumed because in paragraph 7C of 55373, that they also gave the commission the authority, if they wanted to reach and get any portion of these international codes, they could use those also as a technical amendment.
Okay, I'm going to give you 15 seconds to sum up if you'd like.
Well, we would ask you to reverse the order, and we appreciate the time and attention you've given to this.
There being no further case, well, thank you very much for a good oral argument.
Thank you.
There being no further cases in front of the court will stand in recess.
All rise.